Why are there three different associations of lawyers in the same High Court? What are the importance of double appeal in the form of latest patent in the High Court? How is the mentioning system of cases truly operate in the High Court? Hello friends, Pranam. In this conversation, we have discussed these crucial questions with Mr. Sanjay Singh. He is a senior advocate and president of Barrister Association at Patna High Court. We delve into these crucial questions that one only learns through practical experience. I hope this conversation is as enlightening for you as it was for me. Okay, welcome to this podcast, sir. I've had so many requests on my channel, people asking me to invite you, and I thought it was just me, but that is clearly not true. This demonstrates that people want to hear from you, they want to know about you.
Thank you so much for having me. I don't know if I'm competent or to come up to the expectations of so many people, like you said. I don't know, but well, I'll do
Let
my
the
best.
people
Thank you very
decide.
much.
Let the people decide post
Yes.
an hour of our conversation.
Yes.
So let's start this conversation from the beginning, from the time when you have finally made up your mind that you want to dedicate your entire life in the service of this institution, in the profession of law. How did that happen?
Well, you see, I come from a family which is a family of lawyers. I'm the fourth generation in it. My fifth generation is already working. My son, my two daughters, my nephews, they are all coming into this profession. To give a little background of my family, all the cousin brothers and everybody, my father, they were 18 in number, you know, and it so happens that 9 of them were lawyers.
Oh,
So it's a family of lawyers. We have had a long history. I'm the fourth generation. So it never crossed my mind that I have to do anything else but to come into this profession. So after completing all my education in Delhi, I chose to come into this profession. I worked for it. I came in, and it's been since then I'm here, and it's been long, 37 years now. And I never thought of going into any, taking any UPSCs or the bankings or any other kind of service. No.
you're always clear about.
I was
your
always
decision.
very clear, focused about it, and I took pride. I take pride in coming into this profession because I still feel that, you see, this is a profession which like, if I may say so, once Justice Venkatachaliah, Chief Justice Venkatachaliah said that there would be a time when this profession would be replacing all the administrative officers. Now, the old man, I don't know with what perspective he said so, but that was very profound when he said this. So I was very young at that time, but then, that has stuck into my mind, and I try and do the best what I can.
Can you please explain that quote, that statement, that this profession would replace all?
Because you see, what he said was that the times are changing, the society is changing, and everything is now going to revolve around law.
Right.
You see,
Right.
and law is a dynamic thing which keeps happening. It keeps changing according to the socio-economic, cultural background of the country and space. So likewise, if you see in America, you see today all the policymakers, are lawyers.
Right.
I see a book on your shelf which is about policy making. You see, policy makers today, the entire administration is in the hand of policymakers.
Right.
You see, so therefore, it is in that context that Justice Venkatachaliah said that there will be a time, and that, in fact, to a very great extent,
Has already come.
has come. And if I may tell you, Professor Menon, the founder of National Law School, Bangalore, he and Venkatachaliah together, thought about a national law school, the system of national law school, where, it will be a 5-year course. And how far it has helped, I don't know. But
We'll speak about your views on legal education.
that is what was in the mind of Justice Chaliah when he said this, Venkatachaliah, when he said this. And I find that slowly, it is coming to that. We may have administrative officers, police officers still coming from engineering background or other background, but slowly, though, the policy making has gone into the hands of lawyers.
True.
So that is the background when he said this.
Very true. Understood.
Yeah.
So you just mentioned you are the fourth generation
Yes.
in your family
Yes.
who has dedicated your
Yes.
life into this profession. So your great grandfather was a lawyer.
My great grandfather was a lawyer. My grandfather was a lawyer.
Your father and yours.
My father and myself, and then my children.
Okay. Could you tell us one thing from each of these individuals that you have learned, which has helped you professionally?
Okay. You see, grandfather and great grandfather, I didn't have much interaction because they had already left by the time I could, gather my senses, so to say.
Okay.
I was about 6 or 7 when my grandfather left.
Okay.
So no interaction except that childhood memories, of going with him to the court to see him off to the court. And
did all of them practice before Patna?
No. My great grandfather was practicing in the Mufassil town.
Okay.
At that time, Buxar. I belonged to Buxar. Okay. Buxar was a subdivision of Ara, the Shahabad district of those yesterdays. And my grandfather thereafter, he shifted from initially practicing in Buxar. He shifted to Ara district court, and then he was practicing in all the other civil courts in Shahabad district. Would come to Patna High Court also. So not much interaction with them. Okay. But yes,
your father.
My father had a profound, very, very emphatic, if I may say so, effect on my how I think and how I work. My father, practically, frankly speaking, was a self-made man. We see in 1957 he traveled to Delhi. The then Justice B.P. Sinha, who was the first Chief Justice of India, he was a great friend of my grandfather. So he said, you send your son to Delhi and he'll practice there in the Supreme Court. So my father traveled. I was a young baby at that time, so I traveled. So all my education was in Delhi. My father, you see, I have seen my father struggle in the profession, in the true sense of the word. And I have seen his struggle. I have grown with that struggle. You see, it has had a very, very great impact on my life, on my thinking, on how I see life. When I wore the gown for the first time, I walked up to him and he said, "Let me give you 3-4 mantras," and I've tried to follow that. I don't know how far succeeded.
What are those mantras?
The first one was that when a client comes to you, hear him out. Don't just, whatever he's saying is maybe all bakwas, but hear him out. The logic behind it was that he's coming from a district, low from his village, and he's all full of his case in his mind, in his heart, in his soul. And when he comes to you, you are representing the High Court. You are representing the judge before whom he thinks he's going to place his case. So he unloads himself before you. 80% of his satisfaction is there. So he goes back thinking that, all right, I have got a
good counselor,
who has heard me and is going to put it across to the court.
Right.
You see? So he said, first thing that you do is hear him out. And at times you will find such points in his story which may not be there in the documents, in the papers. So that was the first lesson. The second lesson was that if you take a fee of 1 rupee from him, give him the satisfaction of 1 rupee 10 paisa. So that has been my mantra. I try and give the full satisfaction to him. The third was that be an apple tree. Be polite, be humble, and be accessible to people. You see, now an apple tree, when it is loaded with fruits, what happens is that it even a child can go and pluck an apple. So that is accessibility. So he says you be that accessible, so that people can come and talk to you and take your help. And if you can help somebody, please go ahead and do it. So that is the third one. And I have kept those 3 mantras in my head and mind. It is always there, and I work accordingly. I may have succeeded, I may have failed. That's one aspect. But I try and adhere to that as much as I can. You see.
Great.
So that is how, and I've seen him as a judge. I've seen him as a Chief Justice. I've seen how he meets people, how he, even after his retirement, till the day he was no more, there would be people in the evening to see him, and he would sit down and have tea and coffee with them. So that is how how much accessible he was. So I have tried to imbibe that, and let's see how far I can go.
Great, sir.
Yeah.
So all your education has been in Delhi?
Yes, I have right from the nursery class to my universities, everything in Delhi, and it was a very, very good experience, and in fact developed some leadership qualities there, because you see, Delhi University is an experience. I mean, you may come with whatever degrees you want to from there, but it's an experience. It teaches you a lot of things, and which I'm sure, I don't know. I mean, all these modern universities, self-proclaimed universities, I don't know how much they give you, but haven't had any experience with them. But Delhi University is an experience. And I cherish that experience. Yes.
How did the decision to come back to Patna?
Oh, that's a long story. What happened was that after I had passed my law, my father took me to Justice L.M. Sharma. And Justice L.M. Sharma at that point of time was in Delhi. He was a judge at that time, subsequently became a Chief Justice of India. So Justice L.M. Sharma told me that आप घर जाइए और वहाँ जाके 2 साल आप हाई कोर्ट को दीजिए और उसके बाद फिर आप आइए सुप्रीम कोर्ट में वकालत करने के लिए. Now it so happened that I came here and I started practicing 2 years. I joined Rana Babu, very eminent senior criminal practitioner. I joined his chamber and we were doing wonderfully well. Then when after 2 years, when things got over, I went to my father and I said, in the meantime, I had got married in Bihar. So my father, I asked him, I said, do I now shift to Delhi? Because you see, my father's chamber is there in the Supreme Court, still there. We had all the, infrastructure to shift. I had to not do anything there. So I said, may I shift now? He said, अच्छा, दशहरे के बाद देखेंगे. दशहरा खत्म हो गया. Again I went to him. So he said, क्या करोगे जाके? And look at the wisdom of the man. He says, अगर तुम चले जाओगे तो हमारा स्टेट कौन देखेगा? And then he said something very, very touching. He said, I'm growing old, my wife is growing old. If all of you will go to Delhi, then what about our old age? And that kind of, if I may say, put change in my flight to Delhi. And since then I have been here. I mean, and that has taken a sacrifice, let me tell you, because you see, I was educated in Delhi. All my friends, school friends, college friends, everybody's in Delhi.
Right.
And here I didn't have any society as such, so I had to start again, So that's how, and so I'm here in Bihar.
This must be, what, 30 years ago? 30, 35 years ago?
Well, 37 now, because you see, I started my practice here.
So why I'm asking is because what you must have faced or felt 37 years ago, I'm feeling now. I could choose to be in any Indian cities. I could work anywhere. But this is precisely the sentiment what you have just expressed. Because of those sentiments, I'm here. And I'm trying to build a life here.
Yeah.
So that goes a long way. Thank you for sharing
you
that.
You won't regret it.
I hope.
There
really
may be some personal issues, of feeling at times lonely and no friends and all that. You may be feeling all that, but then I must tell you that you won't regret it. And end of the day, you won't regret it.
I don't.
You see, Bihar has its own culture. It has its own work culture. It has its own social order. So you stay with that, and fine. I mean, you just need to gel with it. I mean, it doesn't really take anything away from your life, if I may say so. Yeah.
No, very true. I mean, this state has given me a lot. Professionally, I started my career in the Chief Justice's office in the High Court. How many people are fortunate enough to get that?
We have seen you sitting with your laptop and kind of researching for those Chief Justices that you work with.
Yes.
That we have seen.
Yes. So that way, the state has given me a lot. I'm really hoping that I could return some of which that I have got.
You should think that, because you see, after all, it's everybody's responsibility as a citizen, and that too, if you are an educated one, you have attained a certain level of education. When I mean education, I don't mean the bookish education.
Right.
I mean education in all aspects of life. So then you need to return back, because you see, I tell you, there is a huge and a large scope in Bihar to work. If you have the zeal and the enthusiasm to work for the people, huge avenues open, where you can work. There is illiteracy, education, the health issues. Go to the villages. I am from a village. See, I go to my farm. I go to my village. It is the gap is too big. You see, going to the village and contributing to your society there doesn't mean कि दुर्गा पूजा में आपने 1500 रुपया भेज दिया. You see, that is not your contribution.
It's not.
So, and in fact, I tell you, I mean, I'm coming across many people, who are wanting to come back. I know a person who has left a very, very lucrative job in US to fly down back to India, and now he's an engineer. He's a computer engineer, and he's now setting up an AI a school kind of a thing in Rohtas, near his village. So that is giving back. I mean, हमने तो attain कर लिया. How much of selfishness can I have? I mean, I have attained whatever I had to attain. Roji roti chal rahi hai, I'm all good. So let's give it back. What's the problem?
I often tell my friends that there's this one question in my head that always haunts me, that if all the good students who comes from some kinds of privilege, Providence has been kind to them for them to go to good colleges and universities, and if all of these people choose to work in cities, then that's a concentration of talent, and that would generate access of justice issues in remote areas of our country. That is my thinking. And second is that why do you want to work where the crowd is too much? I mean, market works, especially when you are in the profession of law, when you have to practice, you have to think from a business point of view, where there's too much supply to cater to certain demands. You are just going to be one of those many crowds. Go where there are enough crowds. I mean, those are my thinkings, and I always try to communicate with my friends.
See, legal profession has its own economics. Okay, so you can't look at it from the point of view of demand and supply.
No, not at all. But you have to. I've only said it this way to communicate my points. It all boils down to.
Therefore,
you have to come from a place of purpose. That is there.
Let me just answer that. Go to any court. Go to the Supreme Court. Go to the High Courts. Any court. Even a small subdivisional municipal Mufassil court. You will find that there is a concentration of briefs is only with 5, 10, 15, maybe 25. Okay? हम जब गाड़ी पकड़ते हैं यहाँ से मगध एक्सप्रेस पकड़ते हैं दिल्ली जाने के लिए केस लेके, तो हम किनके नाम दिमाग में रख के जाते हैं? ये दूसरी बात है कि वहाँ जा करके हमारी हवा निकल जाती है कि साहब कोई जो नाम हम सोचते हैं वो नाम कोई 15 लाख लेता है, कोई 10 लाख लेता है एंड ऑल दैट, और हमारी हवा निकल जाती है. लेकिन कॉन्सेंट्रेशन ऑफ वर्क वहीं पे है, उन्हीं के पास है. आप हमारे हाई कोर्ट में आइए, कॉन्सेंट्रेशन ऑफ वर्क किसके पास है? You see, so इसलिए it doesn't really work on the demand and supply thing. Here people will come to you because they have faith, belief that here is a man who is going to deliver, who is going to give me what I require, and he's going to be honest enough to present my case in the manner to give me a victory or to give me my relief. So it works like that, and therefore I would not agree with you there. I'm sorry, but then it's not strictly work as a demand and supply, in my understanding. So you see, this is a very, very very great profession, very glorious profession. Why? Because it gives you an independence of thought. My perception to see a thing, your perception to see a thing may be different. But then I agree to accept your perception, you accept my perception, or we debate about it.
Right.
And in the process we both learn.
True.
You see? So that is how this profession is. I don't know, the dynamics are changing, the dynamics of the the bar is changing. So I don't know really how it is going to fan out in the coming years, but let's see.
I get your point.
Yeah.
Accept it. Yeah. Sorry, not going to debate with you on that. I'm here to learn from you.
No, I'm
I'll
not.
ask my next question.
I'm not in the debating mood. I must say whatever I feel, and this is what I feel. And let me tell you, I frankly, whatever I feel very strongly. Otherwise, I would not express.
Yes, exactly. And like you said, sir, that this is where we exchange our ideas.
Yeah.
And I'll have my own ideas. I come from a place where I'll have my own ideas, and I'll express with you, and I'll get yours. And if that sheds some light on my dark spots that I can not able to see by myself.
Why dark spots?
I mean, dark spots because I've not been able to think of these points through those lenses.
You see, everything is not black and white. You see, there are shades of gray. I'm not talking about 50 shades of gray, but there is gray. And gray is a shade of white, a shade of black, mixed somewhere. So why black and white? Why see life in black and white context? In fact, that is the problem today. We are in order to prove you wrong, I'll paint myself white or paint you white. So that is how we are putting across our perspectives. It's not right.
We have to bring each other at the center. So
Buddha said so.
Yeah.
Golden path.
Yeah.
The middle path.
Yeah.
So, yeah.
Even Aristotle has the same principle, the philosophy of the mean. Too much of something is also bad. Deficiency of something is also bad.
We are seeing that in the world as of now. The right wing and the left wing. A place like America is talking of right wing and left wing, which is considered as the epitome of democracy. And so that's how. Yeah.
Anyways, let's come back to when you came back to Patna. Whom did you join? Whose office did you join?
I joined Rana Pratap Singh. He's a senior advocate, and he was a great criminal lawyer. He was a great lawyer. I would not say a criminal lawyer. It's a different thing that he practiced on the criminal side. I learned a lot of things with him. He was a teacher because he gave me in the 6th, 7th month of my practice, he gave me an appeal to argue. You see, he said, prepare yourself and go argue this criminal appeal. And arguing a criminal appeal is a big thing because you see, it comes with a lot of responsibility and understanding of law, the facts, the scenario, everything. So he gave me that, and I succeeded in that. So that gave me a lot of confidence. I worked with him for about 2 years, and 2.5 years. And then thereafter, I switched and had my own office. And see, at that point of time, what happened was something very fantastic. There was a case called Pancham Singh versus State of Bihar. Pancham Singh was one of the contractors who was building this Durgavati dam, Jalashay, jo ban raha tha, in district of Rohtas. So the state government, he fell out with state government, and so his contract was rescinded. And Mr. Gopal Subramaniam was, engaged to argue that case, and we were doing it before a full bench of 3 judges of the Patna High Court, very eminent judges. So I had an opportunity of working with him, and then while working with him, we developed a kind of a rapport, and then he would, he was at that point of time, even Gopal was growing in his profession, he was trying to make a space for himself. He was very good, but every lawyer goes through that phase. So he would take me to various places to assist him in in arbitration matters, arbitral before various arbitral proceedings, Calcutta, Jodhpur, and all that. And it was a wonderful experience working with him, and I learned a lot. And thereafter, in about, I think I was in 9 years in my practice when Mr. Sachi Anugrah Narayan, who was the then Advocate General of Bihar, he inducted me as a Standing Counsel of Government of Bihar. And I was very young at that time. There were people, who raised his eyebrows as to how come a young person of 9 years and 10 years of practice can really take up shoulder such kind of a responsibility. But I did, and I did pretty good, and that gave me a fantastic learning experience. In fact, that widened my horizon. Otherwise, till that time, I was primarily a criminal lawyer. But to shift to the civil side, those nine years, I was there till about 2005-06 when I left the state, and so that those were, and I have a feeling that every young boy, who joins the profession should work on the estate side, because you see, you get a variety of cases to work on, and to learn, and the rainbow is the canvas is too big. So I learned a lot, and thereafter, since then I've not looked back. I mean, life has been kind to me. I have had my ups and downs, but yes, I've been okay. So.
Is there a difference in practice in civil side, criminal side, constitutional side, in your opinion? I mean, these days people are too pressurized to be expert at something. Everybody is like, what are your masters in? Which subject have most command? So my question is, does that happen organically that you are a lawyer?
I'll give you an example. The culture of solicitor firms that has come in, and it so happens that I'm engaged by a particular solicitor firm to work, and I get a criminal matter to argue. Fair enough. On the same day, I get a matter to argue on the company side. I get a matter to work on the contract side. Pure CPC land disputes. So, you see, law in India or law anywhere has one basic principle. This is my understanding of giving an opportunity. You see, of being heard. Now our constitution also talks of your right to be heard. You see, so the basic principle is that if you're getting a notice under municipal law, or you're getting a notice under the civil law, or you're getting a notice under your service law jurisprudence, wherever, you see, that notice is a must. Okay, so that notice really kickstart your matter.
Right.
So what happens? I file a suit. Okay, opportunity to the other side to file their WS or a written statement, and then again it comes back. I file my rejoinder, and from there it kickstarts. You see. Now the moment, suppose if after 90 days the court says that I'll bar you from filing your written statement, what happens? He runs to the High Court or to any superior court and says that so and so was the reason, and the courts take a very lenient view to send him back and say that all right, you file it within 15 days or so. कहने का तात्पर्य ये है कि हमारा कोई भी आप कानून उठा लीजिए, it works on one thing, and that is of opportunity of hearing. You see, be it any kind of law, even in the criminal side. You see, Section 313 of the CRPC, of course, now something different under the new act.
Yeah.
But Supreme Court has said that it is the most important opportunity given to an accused to hear his side of story. You see, and it has been said that the trial court will take notice of that while deciding the case. So it's about opportunity. Now, if your fundamentals about this opportunity is clear, then every act, you pick up any bare act, and you just have to go through it to know that how it fans out, and then that particular subject, will have its own small nuances,
right,
which with experience of or long experience as a lawyer, you will be able to pick up. Rest is all facts.
True.
Every subject would have what, 25, 30 judgments, right, from 1950 to date. So you have to have a small
25-30 landmark judgments.
Index of so you see, all this concept of somebody being an expert, why don't you ask this question to Mr. Sibul? Or why don't you ask this question to Mr. Abhishek Manu Singhvi, or Rohitki, or all these people? They stand up and day in and day out, in a day they argue 6-7 different kinds of cases. We do it here in the High Court,
Right.
So this is a misnomer. Of course, expertise do give you some kind of a edge, if I may say so. That if I don't know and you know a particular subject, you come to engage me, the assistance which you will give me would be of importance. Of importance. I would not say that expertise is totally to be written off. No. But then expertise helps you to a certain extent. ठीक है, आप कहलाएंगे कि साहब वो सर्विस लॉ में वो बहुत अच्छे वकील हैं और उनको हम एंगेज करेंगे, वो ठीक है, fair enough. That expertise is that he would know the nuances a little better.
Right.
But I don't find I don't have any problem, in not being called an expert of a criminal law or this law or that law. I'm wearing a gown which is a senior's gown. Now I'm required to,
True. It's like you said that clients come to you because they have faith in you. In the beginning of the conversation, you have mentioned Professor Menon. I remember Professor Menon was there at our orientation, and he said something that I still carry because it was so thoughtful. He said that in the course of 5 years, you are not going to learn any laws. In the course of these 5 years, you are only going to learn where would you find the answers to any legal questions that would come in your life.
Yes.
And
I put it in a different way, the same thing. A lawyer is not supposed to know the law.
Right.
He's supposed to know where it is.
Yeah, and to whom should he approach to find the answers?
That's what all.
Great.
It is absolutely on your own self. How do you want to find the answer? You want to burn the midnight oil and find it yourself, or you want to go run to a senior to find it out? Or to run to a so-called expert of the field to know.
Right.
So that's how. Yeah.
Okay. So before we talk about High Court, I want to understand from you how you have seen Bihar, because you have practiced at the High Court in the past 3 decades. What kind of social changes have you seen in Bihar? Where does this question come from? I'll give you more context. I've always imagined that as an individual who are part of the society, and human beings are product of their circumstances. We are taught certain things, we are motivated by certain ideals, and we become part of a formal institution where we have to uphold higher values. But having said all of that, we are part of the environment where we come from. So how much does the society shapes the institution, or the values and ideals of the institution shapes the society?
That's a very, very deep question. Let me tell you that. You see, in the last decade or so, maybe decade and a half or so, the socio-economic, cultural fabric of this state has taken a beating. This we'll have to accept. And the primal reason for taking this beating is the bane of this society called the caste. You see, the caste is playing a very big role in shaping the direction in which the society, its culture, and its economics is going. You see, I'll not elaborate on that because then we'll be treading into the political aspect of it.
Right.
Now, what happens is that the society, it is said that society gives itself its institutions, its officers, its everything. In the last decade and a half, if you see the fabric, the kind of legislatures we are getting, the kind of officers that we are getting, the kind of institutions that we are getting, is getting affected by this bane of the society called the. Let me give you an example.
Yes.
The story is of 1992. A young lawyer at that point of time. There was 1991-92. Yeah, there was an institution called Biscoman here. Okay. Now, Biscoman fell out with the government. Biscoman is a cooperative society, which it fell out with the state, and the state used its power to deboard everybody. So its board was nullified, and it was given to an administrator to work. And when the administrator joined, he found that there was a particular caste which was represented largely in the administration of that society. So he, for some reason or the other, he removed all of them.
He removed all of them.
They left their job. I mean, they were put out of their job. So that those people came to the High Court, and there was a writ application. At that time, there was all these writ applications used to be before a division bench. Today, it is before a single judge. But at that point of time, it used to be before the division bench. So I remember division bench was led by Justice D.K. Sen, who was at that point of the Chief Justice. And it so happened that they got themselves a lawyer, Mr. Govind Das from Delhi Supreme Court. He was from Orissa originally, a pretty learned man. And when he stood up in the court to argue, he said, "Milords, I'll be..." The word he used was, "What I'm going to say would be blasphemous. But still, I would say it, that all these petitioners before you, they belong to one caste, from the same caste." And the reaction of the court was that, "Mr. Govind Das, what are you saying? We are a constitutional court. Can you really talk about caste like this?" That was the day. You see? And today is the day. We are talking caste in and out, okay, in every aspect of life. In every aspect of life. So therefore, what I want to say is that it has taken its toll, yes.
So how was this case concluded? Sorry to interrupt.
Yeah.
How was this case concluded?
It fizzled out. I mean, something happened, and then they went to the Supreme
They are not
Court.
reinstated.
Later on, maybe some of them,
Okay.
or some, I really don't remember, but something happened, and later some of them were incorporated into the, were inducted into the government offices as engineers and all that. But then, be that as it may. So what I'm trying to say is that the bane of the society today is the caste, and we are working on that. You see, it is affecting judiciary also. Let me tell you this. How profoundly, to what degree and all that, I will not be able to specify that. But to a greater extent, yes, it is doing it. It is doing it. And I'm tempted to say a lot, but then I'll zip it.
Okay, adding to the same question, there's a common criticism that while courts can pass progressive judgments, and courts do, their implementation is a challenge. So how do you see the gap that these progressive judgments, some of the progressive legislations, are they implemented?
Forget about a progressive judgment. I'm talking of a very, very simple thing, of a very simple man on the street. He has given his 35, 36 years to the state in service. When he retires, he's supposed to get a pension. And that pension, when it comes to the court, the relief he wants is that, "I want my pension, please." So the court says, "All right, here you are. And this is the order, the direction to the institution that you go ahead and make his payments." After some time, he comes in contempt. Okay? And in contempt, the representations are disposed of, something happens, and that man, poor man, a simple man, is made to run from pillar to post, as they say, if I may say, from one office to the other, from one jungle to the other, for his rightful claim. And what happens? You see, of late what has happened is that now we have Supreme Court which has said that don't call officers in the court, just like that. Or they would say, they have said that call them on virtual mode.
Right.
Now, unless and until an officer is called to the court, okay, the order is not implemented. Okay.
Okay, is it so?
It is so. It is so. And it is happening day in and day out. I'm sorry to say so. So the Supreme Court, sitting 1,000 miles away from here, is perceiving. It is passing a general order which is about the entire country, but it works differently here. Here was a honorable judge. I would not name him, who would, on the very first day of the writ application, forget about the contempt, would direct for the presence of the officer. And I tell you, the order goes, and the next day he is in the court with the pension papers, approved, etc., everything, or with a reason why it cannot be. You see, so what I want to say is that we have diluted our powers on our own. You see, a very, very profound thing, which I may say, you have the powers, the statutory powers, constitutional powers, 226, 21, and everything.
Right.
All those very high-flown, quote unquote, kind of right to life and whatnot. You have everything. The problem is whether you want to exercise it. I'm sorry to say this, maybe this is my opinion, my understanding may be absolutely wrong. The courts have put fetters on their own exercise of power. They have put that. There is a syndrome called representation syndrome. Go file a representation. You are relegating me to the same person who has bitten me. Who has bitten me once, twice, thrice.
Right.
And again, you are sending me back to him. What relief I'm going to get from him? You see, the head may change, the face may change on that table. 8th district magistrate may be changed by another one, but the person, the way they work is the same.
Right.
So that relegation really doesn't help. In fact, what it is doing is it is counterproductive. You see, you may have taken a view that all right, I've disposed of a case. But let's understand that this has given rise to a few more cases, because that person, after the representation been rejected, again comes back to the court. So you're burdening yourself in the process. So exercise of power by the courts has been now diluted, to my understanding. I may be wrong, and maybe the dynamics of law have changed. I don't know. I really am at a loss to understand that.
But there are two things you just said, that there are more contempt proceedings before the court where orders of the court are not complied with.
They are not more. I mean, they are being filed, yes, because that is a jurisdiction, so that is being filed, yes.
But what about the volume? You just mentioned that if the officers are not being
quite in number. But then the expectancy of the client in a contempt, to a very great extent, is not being fulfilled. No. It on some technicality is being kind of put aside. Yes.
So again, I'm trying to understand that there are two things. You are saying that judges are putting restraint on them in passing so to call judgments that can be resolved at the first instance, instead of sending a representation to for the party to go back again to the administration. And then there's also instances where where court exercises power to pass such judgments, then those judgments and orders are not complied with. Both the circumstances persist.
Let me clarify here. You see, representation is not something wrong. I'll give you a small. There are cases where representations are required.
Right.
Okay, like a person coming with a writ of mandamus, seeking a writ of mandamus, and has not represented, mandamus cannot lie.
Right.
So there, if you're doing it, one can understand. But run of the mill, if you're relegating the matter, in representation, then really you're not helping the system, if I may say so. So, what was the question again?
The question was that there are two things that is coming here. First is that court is putting a restraint on them in not passing the judgment at the first instance, and second is when court does, then those judgments and orders are not complied with. So the question is that what's the likelihood of what are the scenarios which are happening more, whether courts are not exercising the powers that they have, and if they do, those are not being complied with.
You see, there are two things. First is, like I said, that the court has the power, but they are not exercising it. They're choosing not to exercise it. They may have their own reasons, I don't know. The second one is the implementation part. Again, it's a soak pit. The answer to this would again take me to the realm of talking about the bureaucracy that we have and the systems in the offices that work. You see, and why it works, let me not spell it out. It's for everybody to guess. But you see, the courts have to be a little alive to the situation that is prevalent in the bureaucracy and the offices. I may say that they are alive to it, but they are not doing what they should do to take care of that. The judicial system, you see, the judiciary of late has gone a lot of change, in its attitude, in its approach towards. It has become more disposal oriented. You see, वो एक था ना, एक गाना आपने सुना होगा, डायन महंगाई खाई जात है, likewise, this disposal.
It is more about disposing the case.
Yeah, disposal. This disposal is eating into your justice. You see, eating into your justice. The justice which I expect, I'm not getting. That is where it comes to.
Again, the question is more because litigants are sent to the administrative officers with a representation, or courts are passing judgment and orders and they are not complied with, leading to contempt.
Either. You see, let me tell you a few things. And this is absolutely from the litigant's point of view. You see, we glorify when we say right to property. There's a constitutional right to property. It is no more a fundamental right, but constitutional right to property. There is a person, an ordinary person, who gets into a litigation pertaining to his property, land, in a remote village in some district. And he goes to the suit. The trial of the suit takes about 10 years, maybe 15 years. So if at the age of 35, he enters into this suit, by the time he gets a decree in his favor, he is already 15 years down his age. He's 50 now, 60 almost. Then, when the execution of the decree comes, the execution is a whole new ball game again. Okay? Now, I'll discuss that later. Let's talk about this decree which he has got. The land for which he is fighting, for which he has got a decree in his favor, is the land which is in possession of somebody else. Now, that person goes and appeal against it. The first appeal, it takes another 7 years, 8 years, maybe 10 years. This gentleman with the decree is now with a first appeal order in his favor. The gentleman in the possession of the property runs to the second appeal court. My friend, today in the Patna High Court, we have second appeals pendency for last 25 to 30 years. You see? Now, for this entire time, that person with a decree in his hand, with a first appeal order in his hand, is running from his village to the district court for execution of that decree to the High Court. And in the meantime, he submits his application for execution of the decree. Now that's another different ball game. Now another run to the Supreme Court and back starts, or to the High Court and back starts. You see, where is the justice to that man? You see, what are we talking? We are talking about a man's right to property.
Right.
We talk of a person's, what is a person made of? Name, fame, money, property, etc. Property is his prestige. It may not be for you and me, but for that one man, it is his prestige.
Right.
He has inherited that prestige from his parents. And what does he give it to his grandson? A pendency of a second appeal in the High Court. You see, this is denial of justice to him. He dies with a very heavy heart that मैं अपनी प्रतिष्ठा बचा नहीं पाया.
In his entire life.
In his entire life. Likewise, a very common thing happens on service jurisprudence side. A person is dismissed in service, from service, comes to the High Court. And the High Court says that, all right, we'll take it up as it reaches. And don't worry, if you win, you'll get everything back. There is no urgency. Okay? Here I put a question. Whose urgency? Urgency of the court? You see, the perception of that urgency is to be looked from which side? The court side or the person who is in peril?
Right.
Now, after 20 years or 10 years, you take up his case, okay, and give back his service, return his service back. By that time, maybe he is retired, his tenure is over, maybe. But that 10 years or 15 years before you could take up his case is penury for him. His family has suffered. Maybe he is the only earning member of the family. Another aspect. Now, these are the gray areas in our judicial system which I'm talking about. A person is convicted of a crime. Okay, I was brought up in the era when a person who has been convicted for, say, 302 by 149 or 302 by 34, the person would be granted bail, except for the person who is the main assailant or the main accused. If he's a rapist, then the person who was a rapist would be not granted bail, but others would be granted bail. Then there was a change in the attitude of the courts of this country, and they said, now you are convicted, so therefore you don't have a right to bail or suspension of sentence. So not before 4 years, not before 5 years. Then it became 7 years. Today it has become 9 years.
9 years before you could secure
you can secure a suspension. Now this has been now even there are two judgments which have come very recently from the Supreme Court. One is that Om Prakash Sahni and then Janardhan Rai. Now Om Prakash Sahni says that a court cannot look into prima facie, it has to look into it only prima facie to come to a conclusion whether they have to suspend the sentence or not. But they cannot go into the evidences, etc. Okay. How do you make a prima facie case? A practical difficulty. So what has happened? The doors are closed. Then it said, all right, 9 years, if the man has remained behind, then we will see about it. What happens? Janardhan Rai says, what 9 years? Even that is done away with. Now, both these judgments, fair enough, has given this direction to the lower courts, the High Court, of not to accept grant suspension or sentence just like that. But where is that small keyhole or a pinhole where a court could exercise its discretion? You see, when you are closing doors, you have to give remedies.
Right.
Now, the remedy would have been that in such case, if it is 9 years or 7 years or 8 years, then his appeal be heard on a priority basis. That would have been a relief.
So that is not being done.
Situation today is that today, Saturday, the court opened, okay, and there were about 8 or 9 benches which have sat, and they were hearing appeals, such criminal appeals. 1995 to 2004.
Appeals that comes from 1995.
Filed in 1995, 2004 are being heard today in 2025. Now the proverbial question, okay, why I say proverbial, because activists always talk of this. You say that after 10 years, 9 years, after 20 years, after 12 years, you hear his case. I'm sorry, not 20 years, but after 12 years, you hear his case. And you acquit him. Who is going to give him his life for 12 years? This is a question which all the activists talk about. It's precisely the question which is staring in the face of the court today. Isn't it?
It is.
So, and let me tell you, somehow we are not finding any answers to this.
I was going to ask that.
See, we are not finding any answers to this. Now, the answers being found are in creating a system of mediation, alternative dispute redressal. Fair enough. But then, how many mediations are succeeding? And why they are not succeeding? There are 2 reasons for it. The first reason is that the person who is mediator, though they are taking all the efforts to train these mediators, to kind of intervene and get it settled, but most of them are not able to succeed. You see, so the mediation is not having its effect. Secondly,
so the cases after mediation comes to court only?
No. The matter comes to the court, and the court says go for a mediation. Okay. Of course, not in a 302 matter, but
no, after the mediation, when the mediation does not conclude a reasonable.
No. What happens is that when the mediation takes place, like I said, there are 2 reasons why it is not succeeding. I'll not say it is failing, but it's not succeeding. First is that the mediators are not that well trained, or they are not armed with any kind of, if I may say so, carrot and stick game, that they can exercise to bring them to the settlement. And second is the egos and the whims run so high between the 2 parties
that
they really need an order of the court to kind of, bring them to the settlement. A mediator is not able to do that. You see, my understanding is that we still are not a society where mediation would help. I'm not being cynical about it, or I'm not being negative about it. It's a very good idea, but whether we can, you see,
the time has not come.
It has not arrived. Maybe mediation in, say, in United States, okay, or any of the European countries, there it is, yes, immediately husband-wife mediation, contract mediation, huge corporate issues mediation. There it is an accepted norm. We have to still reach that, So fair enough. It's a good start. It's a good beginning. But then, to what extent can we take it? You know, I would say, you see, Gandhi gave the local self-government slogan, and all these Nagar Parishads and the panchayats are there because of this slogan. Why can't small issues, there is Gram Nyay in every panchayat, there is a Nyay Sathi or something like that, who looks into small matters. But why can't they be trained, to take care of the small,
right, at the panchayat
level itself, small disputes about land and things like that. Why can't be settled there? So, I think that would help. That would help. This is my understanding. I don't know. I mean, absolutely what I have learned from my experience.
So these
may be 100% wrong, but
so these three cases, you've given an example of a civil case, a criminal case, and
a
service matter. So in all of these cases, you think that these solutions could help?
The mediation solution?
Yeah, the mediation or the alternate dispute resolution. Because when it is against state, you have to come to the court.
In criminal, with this kind of accusations that we have, no,
right.
It will not.
In criminal matters, it will not. If it is against the state, it will not.
It will not.
So how are those problems going to be?
You see, like the land thing which I said, there it could help.
Yes.
It could help.
When it is between parties, then it could.
It could help.
But when it is against state?
Against the state, it may not. It may not. The mediation may not. Though there have been instances very recently where the courts have relegated pure service matters and pure contractual matters to the mediation.
Okay, is it?
Yeah. So, but to what extent have they been successful, I really don't know. Yeah.
So, how are matters where state is a party, so I wanted to speak about two things of these cases that you have just mentioned. LPA jurisdiction of the court?
Not
examples.
Cases, these are not illustrations cases, these are the examples. Of pain. Yeah. Illustrations of pain, if I may call it. Yeah.
Yes, of course. So, one is the LPA jurisdiction of the court. I wanted to speak about that there's a single bench and there's a division bench. So what are the jurisdiction of these two benches currently?
Nothing. I mean, an order of the single judge is writ jurisdiction is challenged. There are other small civil matters where they can be challenged. Criminal matters, they do not go to the LPA benches. LPA bench, that is latest patent appeal, is headed by two division bench by two
latest
judges.
Patent appeal does not come from the constitution; it comes from the Patna High Court's rule.
No, it is incorporated in the rules of the High Court. Has a history of British.
Yeah, it comes from the inception. Since inception in Patna High Court was.
Yeah, that's why it is judicature and High Court. There are High Courts, Kerala High Court, not judicature, but Patna is a judicature. All that is there. Not getting into all those very.
No, because this question is important, and I have read that there are for and against argument for whether or not High Court should have LPA jurisdiction or not.
You see, I'll give you an example. We did have a time when we did not have LPA, patent jurisdiction. All the matters were heard by division benches.
So there were only division benches, no single bench.
All matters were heard by division benches. Then it was relegated back, when pendencies increased and all that pressures came. Then it was relegated back to the single judge, and then we have a patent appeal matter, appeal jurisdiction. Very recently, when Justice Karol was the Chief Justice.
I was part of those cases.
Yes.
So to expedite infrastructure matters.
Infrastructure matters, how that came about, I can tell you. What happened was infrastructure matters, these contractual matters were going before the single judge.
Single bench, and then was coming.
And then the single bench, would maybe grant stay, and it would take its own time, and then come to the division bench. So infrastructural development process was getting delayed.
Right.
So it so happened that the Honorable Supreme Court gave a direction that all these matters be straightaway heard by the division bench.
Okay. The order came from the Supreme Court.
From the Supreme Court.
I thought it was Justice Karol's innovation.
No. Supreme Court.
Okay.
Justice Karol allowed this. I mean, he had to allow it because there's a direction from the Supreme Court, so he allowed it. But what he one fine morning did was that other subjects also, he said, it will be before the division bench.
Okay.
Right. So that was the time when, you know, I representing the bar as such, I had a talk with him and I said, sir, don't do this, because a person, say a case from service jurisprudence, you know, he comes to the LPA, latest patent jurisdiction, and this is his Supreme Court. He is not going to go over and above this to
this is inter-court appeal. So in that court only you are getting.
So he ends here. He doesn't go to the Supreme Court because for him this is the Supreme Court.
But again, sorry to interrupt, but here again the problem persists, no? That the case that you were just illustrating, that if the case does not end and there's always some room for appeal, that like reasonable end is not.
Not going to the Supreme Court is for a different reason. You see, not going to Supreme Court is because he can't really afford it anymore.
No, but when you give a client a jurisdiction like LPA where a case can be challenged, so that does not put quietus to the case, no?
No, it does. It does, because he may not choose to go to the Supreme Court. See, the state may go.
If but the state here again the question comes, how many cases are resolved on the single judge bench without
quite
coming
a number
before
of them. Quite a number of them. It is resolved. Quite a number of them are resolved. And a few which come to the latest patent jurisdiction, they are also, most of them are resolved here only. A very few, you know, where the client is so het up that no, I have to go to the Supreme Court. But you see, the paying capacity of a client here in Bihar is such that it doesn't help him to go to the Supreme Court. He can't afford to go to the Supreme Court. You see, so for him, this is the end. That's how, you know. So that is what I told Justice Karol, that, you know, why are you... So he said, yeah, you are right. So the very next day, you know, I think on the next Monday, the jurisdiction was reverted.
Okay.
You know? Yeah.
So what he tried to do is that all the matters, irrespective of any subject matter, will be heard by division bench.
By the division bench.
And no LPA.
No LPA.
So though there's no matter of appeal. So straight away from High Court, it will go to the Supreme Court, if at all.
Yes.
Okay. So according to you, what I understand is that LPA, the jurisdiction of LPA serves some purpose, and it should be.
It does. It should be there. It does. It does. It has a logic behind it. You know. It has a very, very sound logic, in fact, if I may say so. It is a very important part of justice delivery system. You know, it's a different matter that it takes time.
It takes time, and the argument against it is the same. The case or the example that you are illustrating, that matters are not given a reasonable end in due time, and since there are jurisdictions like this, there's a room for appeal and party keeps on litigating. So that is an argument against it. So anyway, since we are talking about Justice Karol's tenure, there was one more thing which was controversial, if I may say so, is a lot of people were saying that what his lordship did was centralization of mentioning. So matters were mentioned before the court. Can you please tell our listeners that what are mentioning? What purpose does it serve?
Mentioning is when a lawyer and a client feels that the matter is of importance and should be heard on a priority basis,
which is not part of the cause list on that day.
On that day, or is not being taken up. You see, it may be a part of the cause list, but it's not being taken up. Say it is at the bottom of the list.
So it's a plea before the court.
There is a situation where it is not being heard for all these while. There is a situation where an emergent situation has arisen. For example, I'll give you that a person has come against encroachment notice. You see, that his house is encroaching certain part of the public land, and therefore it needs to be brought down. There is a notice from the concerned officer. Now he has filed a writ application against that notice, right? But then there is a situation, and it is lying in the list. But then there is an emergent situation where there is a crane or a bulldozer which comes to his. Not exactly a crane, I'm sorry, a bulldozer or that all those machines which has come to kind of demolish. Now that is the emergent situation. So he comes to the court and says that please hear me on a priority basis, and the courts do take that. So that is what mentioning means. But what has happened is that every case, you see what the problem is, that a client's perception of his case is very important.
Right.
You know, his case is the most important.
Right.
And he has his own perception about it. Now, I as a lawyer have to choose whether his anxiety becomes my anxiety. You see? Now, if I can't differentiate this, then what happens is that I because of his apprehension or his anxiety, I take that anxiety upon myself, whether it is urgent or not. I go before the court and say, "Isko sun lijiye." And the court says, "Nothing doing, go. Come in your queue."
Right.
You see, I as a lawyer will have to decide whether I should or I should not. Okay, but then most of us, under the pressures of our profession, you know, do succumb to that pressure from my client, from the client. And
but is there no guidelines to that regard? No SOPs to that regard? What is urgent?
There can't be any SOP to this regard, for the reason that, you know, the only thing which has been said is that the subject with which before the roster bench, the court which is in season of that subject will decide whether it is important or not, or urgent or not. You know. So what happens is that there is on every day in the morning there is about 20 people standing in front of the court.
It starts from mentioning. The court starts from mentioning.
Yeah. So it's like that. I mean, and you see, there can't be really any system to kind of evolve that. Now, Chief Justice Karol did that, and then later he let it go. So because then he couldn't take the pressure. So he said, "All right, let it be before the same benches where it is to be the roster is." So that's how it works.
No, but what was the intention behind? What was he trying to fix?
He was trying to centralize it. You see, he was a very well-meaning person. Let me tell you, very pious, very a person with very good heart and mind. He was very considerate towards lawyers, towards staff, towards everybody.
Yes,
even to the extent that to the munshis, you know. So he was a God-fearing man, and so he thought that if I take it upon myself, maybe some good will happen. Intention was very, very good. There was absolutely no two doubts about that. But then, you see, it doesn't work out like that. You are taking too much on your head, too much on your self. So he had to let go. You know? So it was a kind of an experiment which he undertook. No, you know, criticism about that. You know, every Chief Justice wants to work the way he wants to. He is the person who is controlling the administration of the High Court. So therefore, no blames on him. Yeah.
But in a situation in mentioning matters, then it all boils down to the discretion of the judge.
Yes.
Yes. What the judge feels.
There is no law to it.
Yeah.
There is no law to it, and it is absolutely his discretion. You see, I tell you. Like I said, आपको एक छोटा सा एग्जाम्पल देते हैं. Some time back, there was a move to bring the profession of lawyers also under the definition of service as in Consumer Protection Act. Right?
Before the Supreme Court.
Yeah. Now, why were we opposing that? Let's understand that. The lawyers opposed it. Now, why did we oppose it? You see, a client who comes and files his case, for him, his case is the best. For him, his case should have been allowed. Okay? Now, this is his perception. What is the lawyer there to be? Lawyer says, all right, I'll file it. This is the law, this is the fact, and this is what you can get or you cannot get. So I file the writ application or any application that I file. The decision is to be made by a third person who happens to be a judge. He may agree with me, he may not agree with me. If he doesn't agree with me, okay, the person who is to be blamed is not the judge. The person to be blamed would be the lawyer. Because the client, in his perception, would feel that my lawyer has not done it well. And we hear it. I mean, at times when the clients are sitting in the courtroom, they do come out and say that aapne ye point nahi bola. आपने ये नहीं कहा, आपको ये बात ऐसे कहनी चाहिए थी, you know. So they are too high on their own perception. Now I place the case according to the facts, according to the law, and according to everything, not according to his perception. And there is a third person called the judge who decides it. So where is the control of an order in my hand?
If you are dissatisfied with whatever has happened,
you blame it on the lawyer. And therefore, what you'll do is you'll write a letter to the bar council, and there were a whole lot of things in it, and you would write and you'll say that he did not do this and he did not do that.
So I followed this argument before the Supreme Court.
Yeah,
I don't remember who was the lawyer, but I really like the point that stuck with me, that if there are 5 judgments in regards to the case of the client that I'm representing, and if my client is asking to hide those 3 judgments which are against him, I cannot do that.
Or simple, I'll tell you one thing where many lawyers have been hauled up and pulled up by the High Court. You see, there is a rule now that in paragraph 3 we have to declare as to what is the antecedent that this man has, a criminal antecedent that.
That disclosure has to come from the lawyer.
Yes, but now the best part is that this declaration, they would it has to come from them. They know better. I don't know how many cases you have on you. Now, what they will do is, they will give me 3. There are 5 cases, they'll give me 3. And if I get to know about the other 2 and I ask, ये 2 क्यों नहीं बताया? They will say, इसमें तो bail हो गया हमको. या इसमें हम acquittal हो गया हमको. But the High Court doesn't say so. High Court says, कुछ भी हुआ है, you explain. Now, what happens initially when this rule came? Now, I am not at fault, because I am not being told. So how do I incorporate in the petition? Now I am not at fault, or the junior lawyer who is drafting that advocate on record is not at fault. But the court initially started taking it as a fault of the lawyer. So we had to take it up with the High Court कि भाई आप हम पे नहीं डाल सकते हो, हमारे मुंशी पे नहीं डाल सकते हो. The person who is swearing the affidavit is the person responsible for the whatever has been said in the petition. So likewise, there are 10 judgments. I'll be citing 5, or I'll be citing all the 10. Now he cannot tell me that don't cite those 2 because that is against me. You see, so therefore, what I'm saying is, coming back to the anxiety part. It is I who have to decide whether this matter needs to be mentioned before the bench. The day we lawyers start doing that, separating their anxiousness, don't allowing that their anxiousness to start riding my anxious, making me anxious. I think I will decide whether I'll mention or not. I don't. I mean, I'll be very, very candid about it. You will seldom find me in the courtrooms, mentioning any matter, unless and until heaven is falling.
Unless you see that there is
a reason for it. There is a reason for it. I don't go and mention. Because then what I'm doing is anxiety, number 1. Number 2, wasting my time, the court's time, and then getting what?
Rejection.
A rejection.
First thing in the morning.
First thing in the morning. So I don't. As a rule, I don't allow their anxiousness to become my anxiousness.
But I still feel that there should be some guidelines so that we can show it to our respective clients.
That there really can't be.
Like really you just, again, you illustrated an example, no? That if there's a demolition drive, that's an urgency.
They do it. They do it.
I'm
yet to find out a court where a demolition is to happen or something urgent is to happen. Heaven is going to fall. That the court has not entertained. They have. Yes. I can't blame. We can't blame the court for that.
Right. So again,
but let me tell you. Like today morning, I had a client. Now he has been convicted for a particular crime. His revision before the district court has held him guilty. It has upheld the trial court's judgment. Now he is here before the appeal before the district court has been upheld. He has been convicted by 2 courts now. Now he is here in revision. Now he is coming and banging his head saying that, why don't you mention my matter? On what ground? The moment I do it, the Honorable Court will say you are convicted by 2 courts. What is the urgency? Unless you are so sick in the jail that you can't live there.
Right.
Or some heaven is falling. Okay. Otherwise, what? So therefore, I told them, I said, go home. Nothing doing. I'm not doing it. You see. So that's how things are working. There really can't be any situation where a judge can be forced to adhere to a kind of a protocol for mentioning. I doubt that. I doubt that. Though let me tell you that all the courts are very, very accommodative. They all take all kind of pains to go. You see, at times they say, आप सब लोग slip दे दीजिए, मैं allow करूँगा या reject करूँगा. A particular court, about 3-4 days back, received something like about 102 slips.
There's e-slip also, no? E-mention.
No, I don't know if it would be there. I really don't know. But then there was this mentioning. That e-mentioning thing is in the Supreme Court, not here.
Okay.
Now that mentioning, he took 102 slips. That gentleman, after 4:30, when he gets up from his court, after doing all that work, he is also a human being. Remember that. So what does he do? He goes through those 102 slips, allows 6 of them, rejects all of them. And this is the result of what? The client's anxiousness becoming your anxious.
106 matters can't be urgent.
Can't be urgent.
Right.
You see? So likewise, courts are evolving. We are burdened. There is no. You see, average filing in the High Court per day is approximately 450 cases. And 450 cases per day, average, multiplied with 210 days that we work. See how many number of cases are there. Yeah. This is a very, very debatable thing. We have debated over this a lot of times about the pendency and everything. But the trouble is there. The problem is there. Yes, we are living with that.
Okay.
Yeah.
Anyways, so moving forward, I wanted to speak about you're a president of one of the associations at the High Court.
Yes.
So Patna High Court has 3 associations. So why do we have 3 associations for one institution? Let's start.
That's a good question. It so happened that, you see, how my association came into existence. You see, when we separated from the Calcutta High Court, there were quite a number of barristers, who shifted to Patna to practice. The last barrister who was there with us passed away in 1982, in 1982, yes. And so this was called Barristers Association. It was a kind of an elite association where only barristers would be the members. The Advocates Association was the association of which the member was Rajendra Prasad ji. He was the member of that association. तो हमारे यहाँ कहते हैं कि वो लोकसभा है, ये राज्यसभा है. And then in between, very late, a third association came into being. अगर मैं कहूँ तो कुछ वकीलों की जिद पे वो बना और उसको Lawyers Association कहा गया. And that is how we have 3 associations. But the oldest one is us.
Barrister. That was the original
barristers. And the entry of general lawyers only started very recently. And we had greats like Baldev Prasad and Balbhadra Prasad and Thakur Prasad and all these people, all these great people, who are members of our association. So, and if I may boast about it, let me tell you that today on the bench we have something about 17 of them from my association. I
mean, the leader also tells a lot about the association that we represent.
No, don't do that.
It is a given fact that your association is the most elitist.
In fact, I tell you, we have the library. We have a library which is as good as the judge's library. At times, maybe you'll find a few books which are not there in the judge's library also.
Okay.
So, and it's a big responsibility on us to maintain that library, because you see, the books are becoming old, and we were planning to do a lot of things, but then paucity of funds and all that. So, but we have books and we have a culture. We have.
Is there different entry criteria to become members of these associations?
That's a. Well, yes. I don't know. I mean, how they were being inducted prior to my taking over as a president. But when I became, I chose 2 criteria. First is the background of that person, who wants to become a member, and the general perception that we have about that man. Because you see, in the High Court, we generally know who is who.
Right.
So the general perception that we have about that person. So then we kind of induct him or her. This time in my tenure, induction was a little big. It was almost about 180 odd people that we inducted, for the simple reason that, we got a new building where we got a extra space. A third floor was given to us. So we had space. So just for that space, we, inducted members. Otherwise, when my first election took place, we were how many? 380 members. Today we are about 600.
Okay.
Yeah. But I chose to give only induct young boys and girls, who have come in very recently in the profession, 2 years, 3 years, 5 years, that kind.
I believe the membership fee is also
very exorbitant. Yes, we have kept it because of that. Though I tell you that now that money, that fee also we are finding is very much accessible for many people. They say, don't worry about the fee, please induct us. I say it's a big responsibility, because we try and keep people off, and at times there are people, such kind of people whom we can't say, they come very highly recommended, and we have to choose. So for the interest of in the interest of the association, we say no. Yes.
Is there a switch between members? People switching from one association to
no
another?
there are people who are members of all the three associations.
Oh, is it?
Yeah.
Okay.
There are people who
What's the advantage of that? You can access all three libraries.
You see, I tell you, no access to library. You see, what happens is that when they came to the High Court, they wanted to join a association. So becoming a member of the lawyers or the advocates was much easy. Go fill a form and become a member. Nobody asks you anything. हमारे यहाँ difficult है. But they keep trying. So very late in their professional life, they have been inducted. Maybe, if I can, not boastfully, very respectable person, God, rest his soul in peace, Ram Balak Mahato ji, who was our Advocate General and everything, he was not given the membership. It was only very late that, we gave him. So it is difficult, yes. It is difficult.
So it's a elite thing to be part of.
Yes, if you say so, you can use that word. Yes, I will not, but yes, we are different. We are not elite, may not be elite, but yes, we are different. Elite would be a very
elite is because it's about since there are very few people who are part of this association, that makes it elite. That other people wants to become.
You see. Barrister association gives a different kind of a glamour to you, if I may say so. कहाँ के member हो भाई तो barristers के member.
What other benefits does one get by virtue of being part of a particular association? Like access to seniors, library,
seniors. You have a good working condition. You can sit down, work. You can. I know my senior Rana Babu used to prepare all his cases there only. Between the cases, when he's not arguing before the court, he's sitting on the table and he's working. There's so many. There was up to thoda sa hangama ho gaya hai because of the bheed बढ़ गई है. लेकिन there was a time when you will find absolutely pin drop silence. People would not even whisper. We have seen those days. Yeah.
Does the association also impose? The last time I met you, you told me about this one instance where you went to Uttarakhand and you found that their bar association.
Oh, you're taking me to that.
Yes.
Yes. In Uttarakhand, we went to the civil court for a client's case. And it so happened that the gentleman who was, with whom I was working, there were three, it was a civil case, so there were three seniors, who could be engaged. So, and there were three parties, so one each had engaged. So I had a choice of engaging one. So I engaged. And in the evening, he was very kind, since we had gone from Bihar and all that. So he said, Aiye. So there was a little wine and dine and things like that. seeing a small, chance, I said, sir, if there could be any relief in the fee. So he took me to his chamber, and from the drawer, he took out a kind of a, if I may say so, a memo, where it was very specific. It was the Bar Association's memo, and there it was very, very clearly written that for what thing, what case, what fee would be charged. And this gentleman said that, see, I have a choice. Either I'll charge you the whole fee, or I will write to the Bar Association saying that I'm not charging any fee from these people because they happen to be related to me. After that, I just couldn't say anything. You see, that is another problem, that our High Court doesn't have a kind of a benchmark of fees, which is very, very detrimental to the young members of the bar, because if a senior is available for some a amount of money, why would anybody engage a junior boy? You see, so that is a problem we face. Yes.
So after I spoke to you last time about this instance, I did some research, and there's this landmark case that comes from US, Virginia State Bar.
Yeah.
So I don't know if you're aware of this case or not. So there's this lady who wanted to do her title search. And in the Virginia State Bar, similar thing was there, that below a certain price, they cannot work. So she challenged this, that why this could happen, because she was not able to get her title searched for an amount that she wanted a lawyer.
She could not afford it.
She could not afford it. And she went to the court and she challenged it before on the grounds of antitrust laws, that fixing a price is against the antitrust laws. And there were all these arguments that, again, it's a noble profession and we cannot bring a price like that. It's not a commerce in its strict senses. But the court did not agree with that view, and it said that you cannot put a price. And since then, there's a competition between lawyers' fees as well. So
that's okay. You see, we are not here talking about competition between, for lawyers' fee. What we are talking about is the ethics. You see, I tell you, a senior is responsible for, when we wear a senior's gown, it comes with certain responsibility. I don't know how many people really know about this, but it comes with a certain amount of responsibility. I am responsible for the conduct of my junior friends, my colleagues, and I'm responsible to bring them to a certain level, both professionally and in their conduct. And, keeping all that in mind, I should not take any fee and every fee that comes my way.
Right.
You see, because otherwise that boy or the girl will not develop. He or she is putting in the hard work. He or she is coming with all the research, with everything. I expect 110% out of them. Then why would they not get a proper fee? You see, this problem is so much that very recently there was a judgment from, I think, Madras High Court or something, where they said that a stipend of 20,000 rupees is fixed for every junior. Every senior needs to give that to a junior. I'm hearing this that the state of Bihar, is perhaps going to take a decision to give every junior 3 years, for 3 years period, starting 2024, for a period of 3 years, a monthly stipend of 5,000 rupees. You see, they also have their
right.
Gone are those days when we joined. Would you believe? I joined Rana Babu's chamber, and it was a very, very good chamber. So good filing chamber. So what happened was that, for every wakalatnama that I signed, I used to get 110 rupees. Okay. So it so happened that, I would get, by the end of the month, I would get something like about 2,000, 2,500 odd. In those days, that was good enough for me to my pocket money. रहते तो हम father के hotel में थे, if I may use that term, कि बाबूजी के घर में रहते थे, ना किसी चीज की परवाह नहीं थी, खाना है, पीना है, सब, everything was taken care of. But pocket money was something which
for your personal expenses.
For my personal expenses, those 2,500 rupiah was good enough. So likewise, these children also need.
Right.
you know. But then the juniors today will have to realize that this is a profession where you start getting money only after 5 years of gestation period. You know, it doesn't come in easy. No senior is going to give you money. Sorry. Though it is their responsibility, yes, they should. But it doesn't come in easy. You know, हमारे यहाँ अगर मैं उसको आप थोड़ा सा मैं ग्लोरीफाई करके बोलूँ रिलेशनशिप बिटवीन अ सीनियर एंड जूनियर, तो इसको आप कह सकते हैं कि इट इज समथिंग लाइक गुरु शिष्य परंपरा. You know,
where first serve, then you
not serve. You have to be, आपको समर्पित होना पड़ेगा. अगर आपको सीखना है, अगर आपको कहीं पहुंचना है, तो आपको समर्पित होना पड़ेगा. क्योंकि हम आपको क्या सिखाते हैं? हम आपको बहस करना सिखाते हैं, हम आपका कॉन्डक्ट सिखाते हैं, हम आपको नुआंसेस ऑफ लॉ सिखाते हैं, हम आपको प्रैक्टिस सिखाते हैं. तो आपको कॉम्पिटेंट होना पड़ेगा उस चीज को एक्सेप्ट करने के लिए. मैं एज ए गुरु क्या सिखाऊंगा वो दूसरी बात है. मैं एज ए गुरु सिखा सकता हूँ कि नहीं सिखाता हूँ वो दूसरी बात है.
I have a question here, sir.
Yeah.
Can these things not be taught in law school, in the university?
I'm really grateful you're asking me this question. You see,
because 5 years, the gestation period that you're using, post 12th or after graduation for 3 years, post 12th for 5 years. 5 years, a student is devoting their time in university to learn precisely.
I'll give you an
everything
example.
That you just
to answer
said.
This, I'll give you an example. You see, today what is happening is young boys coming from these national law schools, they are coming with a, if I may say so, and I'm sorry for my saying so, they are coming with a very exaggerated, misplaced overconfidence. That they are coming from there, so that everything is hunky-dory, they know everything. They are sab janta singh. You know? Which is not. Law is not about that. उस 5 साल के अंदर लॉ में आपको सिर्फ इतना ही बताया गया कि कानून कहाँ पे है. आप देख लीजिए, सीख लीजिए, समझ लीजिए. अब होता क्या है कि अब उसमें से कुछ जो है वो हाई कोर्ट में आते हैं, कुछ जो है वो चलेगा. उन्होंने हाई कोर्ट में आए तो उन्होंने किसी सीनियर को ज्वाइन नहीं किया. 4-5 ने एक ग्रुप बना लिया, एक कंपनी बना ली. उसमें से 2 पूना में हैं, 2 बॉम्बे में हैं, 2 दिल्ली में हैं, एंड दे फॉर्म अ नेटवर्क काइंड ऑफ अ थिंग, और वो काम करते हैं. You know, but they have not worked under any senior. So though they have not learned many things which they ought to have learned when they would have been under a senior. Now be that as it may, this is one group. Now many of them are now going before the civil court to practice. Now here my request would be that in the curriculum of these 5-year courses, 2 things should be inducted. Okay. You see, civil law is the basis of all law.
Right.
आप रिट बहस करो, आप IPR करो, आप
even before tribunals.
Even before tribunals, CPC is the thing. Now, आप CPC की कितनी क्लास लेते हो? You see, so there should be a great exercise on CPC. Number 1. Number 2, there is another very important aspect: art of cross-examination. You see, art of cross-examination doesn't come from reading books. It comes from 2 things. One, that you have worked with a senior, a good senior who is very good at cross-examination. Okay. And second, you have learned the law, the ingredients of the sections. Then you will apply to the facts. And मेरा कहना है कि आप जो मूड कोर्ट्स करवा रहे हो, you know, इसको आप cross-examinations करवाओ. Teach them the art of cross-examination at that level. Then you will have proper trial court lawyers, you know, who can conduct either civil or criminal trials.
That is happening. There are criminal trials as well.
You see, so that should happen. Now that is not happening. और आप आ जाते हो और आके आप practice, भाई गाउन पहन लिया, कोट पहन लिया, तो आप तो हो ही गए ना. You know, so that's how it has to evolve. It has to evolve. You know, this is my understanding. I don't know. I may be wrong.
No, where I come from is that we don't see a gap between the theoretical education side of it and the practical industry side of it. the kind of huge gap that this profession has, no other profession has such kind of gap.
You see,
Induction is
like
too hard in this profession.
like I said, हमारे यहाँ आप interns भेजते हैं. Come to the High Court and see what the interns are doing.
No, internship does not work.
It doesn't work. They
you.
will come to some uncle advocate of theirs and take a certificate. Okay? आप बहुत करोगे, मेरे को फोन करोगे और कहोगे कि साहब इस बच्चे ने आपके यहाँ इंटर्न किया था या नहीं किया था.
2 months, 4 months, it does not work. 2 years.
आपको सबसे पहले मैं बताऊं, there has to be one thing very important. आपके अंदर एक ललक होनी चाहिए, आपके अंदर एक अलग होनी चाहिए सीखने की. You know, अगर आपके अंदर वो अलग नहीं है और आप आगे की पहले दिन से मेरे को हो क्या रहा है, मेरा वो फ्रेंड फलना जगह चला गया उस कंपनी में और उसको वहां पे लाख रुपया मिल रहा है. What am I getting here? Working with this senior, he'll give me 20,000 rupees. How does it matter?
That is the difficulty.
That is the difficulty. You see, Professor Menon, we started with him. Let's end with him. You know, otherwise, I don't know.
That's okay.
So, Professor Menon, he would in the interview, while interviewing boys and girls to induct, he would ask, "What do you want? Do you want to practice on the litigation side, or you want to practice in a corporate world? If you want to practice in the corporate world, I'm sorry, I'm not giving you admission." This was so hard.
This was before NLS, the first law school.
Yes, the first law school. You know, so I tell you, I mean, my brother went there, okay, and in his interview, he said, "Give me a situation." He said, "Why do you want to come to this profession?" So my brother started giving him all that, you know, the glorious
off
the book, glorious profession, this, that, blah, blah, blah. And he smiled and he said, "Do you know, on any street of Bangalore, you will find black coats fighting with constables. How glorious is that?" You see, that was the kind of thing that he had in him. And he would say that, "Why would you not?" उनके moot courts होते थे, आप चल के देखिए साहब, it was a very difficult moot court that they used to do. You know, today moot court is just a part of the curriculum. Like it's not really doing something. I really pray that, you know, I'm no one to comment on them. I'm no one to say that they are good, bad, ugly, or whatever. But yes, things are wanting. Things are wanting. Out of 10, maybe we'll get 3 or 4 who are very serious, who are working with us and who are doing things.
Out of 10, only 3, 4 are choosing to come to.
No, not choosing. They are coming and working. But 3, 4 of them are real serious. Like I said, they are competent to learn. They are with a guru, you know, with a senior where they are trying to learn. They are not in no hurry. हमारे ज़माने में कहते थे ना कि साहब, हमारे से क्या, हमारे से पहले ज़माने में भी लोग कहते थे कि साहब इस प्रोफेशन में वही आता है जो कि ज़मींदार परिवार का होता है, जिसको रहने का प्रॉब्लम नहीं है, जिसको खाने का प्रॉब्लम नहीं है. यहाँ तो कोरोना के पीरियड में आपको मैं बताऊँ, I did death reference of 59 of my friends. You know, 59 lawyers passed away in the High Court. You know, Justice Karol was doing the reference. And many of them left the profession and went away and started living in the villages doing Mufassil courts, working in Mufassil courts, because they could not afford here. You see, money, you know, the large section of lawyers is in trouble. Yes, let me tell you. कभी आप उनसे भी बात करें, आपको पता लगेगा कि उनका कष्ट क्या है, उनकी कठिनाइयाँ क्या है. You know, 2 केस, 1 केस पूरे दिन में आता है. They run on a Friday evening. They run to the civil court, you know, to beg for cases. हम उस पर हंसते हैं. Let me tell you, we all people sitting who are well, you know, cushioned life, you know, who are very cushioned in the profession. They laugh and they, you know, give them a word called, they have, you know, monikered them with a thing called Sanichara, you know, कि वो शनिवार को जाते हैं तो Sanichara. But then we are laughing at them, but look at their position. Look at their position. You see, for them it is a bread and butter case. So that's how the profession is. Yes, it takes a lot of blood and sweat. You know.
Right. At least knowing about it, what's ahead is useful. I mean, which is what I believe we are trying to do.
Yes.
Okay. So this is going to be my last question, and the last question of the podcast comes from our previous guest. So the last time Mr. D.V. Pati was here, and the question is, what contribution does a lawyer make to society, in your opinion?
Talking for myself, it is your responsibility to tell the society the direction with which they are going may or may not be right. You see, it is my responsibility. If I can repair, I started with that, let me end with that. The socio-economic cultural fabric जिसको अब हम तार तार कर रहे हैं, अगर उसको हम कहीं रिपेयर कर सकते हैं तो दैट इज माय रिटर्न टू द सोसाइटी. अगर उसको हम रिपेयर कर पा रहे हैं तो दैट विल बी माय कंट्रीब्यूशन टुवर्ड्स द सोसाइटी. You see, that is something which I really want to do. I make some efforts to do it. I'm no Bhagwan. I'm not here to show myself as Mahan. But yes, I do my bit in whatever way I can. And
so it's a privilege and honor to talk to you. And
thank you so much.
And the fact that you come from a state where I come from, I take a lot of pride in that fact.
I take a lot of pride. I'm a true Bihari. I'm a brilliant Bihari, let me tell you.
Thank you so much.
And I take pride in that, and every Bihari should take pride in that.
On that note, thank you very much.
Thank you very much, and it was great talking to you. It's nice that you allowed me to speak my heart out.
Yes.
And let's see how people take it.
Yeah, sure. If we have derived any value out of this conversation, please consider supporting us by sharing and subscribing to this channel. Thank you.